A new investigation from the Wall Street Journal finds 131 judges nationwide broke the law by participating in cases in which they had financial connections. Since 2010, the paper reports more than 600 times a judge oversaw a case involving a company where they or a family member owned stock. These revelations have not only unearthed legal red flags, but have also raised questions over impartiality, conflicts of interest, and oversight. James Grimaldi is one of the authors behind this story, and he joins me now. He's a reporter for the Wall Street Journal. James, welcome. Tell us a little bit more about your reporting and how you uncovered these conflicts of interest among federal judges.
Well, what we did was we obtained every financial disclosure for every federal judge for the past 10 years with the help of a nonprofit organization called the Free Law Project. They have been digitizing these forms. So we took that data and we then looked up every judge's case, especially those judges that had individual stocks. And we looked at the caption of the case. So if we had Judge Smith, who owned Acme stock, we would go and then search and see if they ever had a case involving Acme in their courtroom.
And so what were some of the more egregious conflicts of interest you uncovered? Although I should note that any conflict of interest is illegal. The law is pretty clear about that. It states that it doesn't matter if the interest or the holding is big or small. There can be absolutely no connection, correct?
That's right. It's a pretty bright line test. If you own any share or any equitable interest in a company, however small, you must recuse. But we were able to find, it's hard to say which one's the worst, but we do have a number of judges with a lot of examples. And one of those we feature on our webpage today, and he is Judge Rodney Gilstrap, who happens to be in the Eastern District of Texas. And in that federal court, we found 138 cases since 2011 that involved companies in which he or a family member had a financial interest more than any other federal judge. But, it depends on how you look at it. We also have a case involving our story that launched yesterday in which a judge in New York City, Edgardo Ramos, heard a case involving an insurance company in a lawsuit with Exxon over pollution claim. So Exxon had some pollution that got into some groundwater, and TIG Insurance was a dispute over who was going to pay for it. He ended up siding with Exxon, while at the same time he owned between $15,000 and $50,000 in stock in Exxon. And not only that, he added interest onto the $25 million award. He added $8 million interest. Now, he told us that, that it was a subsidiary of ExxonMobil and that he missed it because there was a missing word in the name of the company. The word oil was apparently not in it when the case was assigned to him. So it's interesting, you get various excuses that were offered by the judges.
Yeah, I was going to ask you what the response has been, both by the judges, but also by the larger legal community. I mean, what sorts of repercussions could these federal judges face? There are some in the legal community that when they read your report said that these judges should all be fired.
Well, that's interesting. I hadn't seen that one, but I can tell you that even before we published, we went to every single judge that's in our database. And when we alerted the violations to them, we had 56 judges who directed their court clerks to notify parties in more than 300 lawsuits that they should have recused themselves. That means a new judge might be assigned, potentially upending many of these rulings. There's been a lot of reaction, I think, in the legal community, at least the lawyers and law professors who tweet, and we've gotten a lot of emails, including a lot more tips that are coming into us. And we've even heard from some members of Congress, some of their offices on the Hill, that think maybe the law needs to be toughened up in order to prevent this in the future.
Well, this brings up a very good point, because as I was reading your reporting, I was sort of struck by how, number one, how powerful federal judges are, and the fact that they seem to have very little sort of official oversight. So what sorts of guardrails exist in terms of federal judges and making sure that these sorts of financial conflicts of interest are disclosed?
Federal judges are in the United States Constitution. They are appointed for life with the advice and consent of the United States Senate. They can only be removed by the same way that you could remove a president, which is through impeachment. Obviously, that's a pretty serious sanction, for it to get to that level. And impeachments have happened to federal judges, but once a decade. And it's unlikely, I think, in some of these cases, unless you could find some other underlying problem, that they would be brought up on impeachment. So what can happen is the case could be reheard, but in many ways that sort of is a penalty for the parties in the case, because they're as they say, justice delayed is justice denied, and you're trying to get this case resolved in a timely fashion. Sometimes it benefits one side or the other, but it certainly does not benefit both sides. But there is another remedy that's possible, and it's all kind of regulated. So judges can have ethics complaints filed against them, and those are generally heard within the federal circuit, which will review the ethics complaint and most often issue an opinion that is sealed. So you can read sometimes these opinions on the circuit websites, but they'll most commonly not ever cite the judge's name, only in extreme cases where you've had judges who have done some sort of excessive wrongdoing that falls short of, say, worthy of impeachment.
So, considering your reporting and considering a recent Gallup poll that finds U.S. faith in the judiciary branch has slipped to a near all-time low, only 54% say they have a fair amount or great deal of confidence. Is erosion of trust in the courts a true concern? Does there need to be a more visible shoring up, if you will, of oversight so that just to restore confidence?
Well, this law was created for that very reason in 1974. There were a couple of scandals involving a Supreme Court justice and someone appointed to replace him that had to do with financial interests. And Congress said, we need to protect the integrity of the judiciary, and the way to do that is to have this really hardline law. I mean, many of the judges who even acknowledged that they violated the law and went into court and said, I should have disqualified, all of them are saying, well, I never had a conflict of interest. I never had a real conflict of interest. I never had a real bias. And, they may even say, well, I only had under $15,000 in shares, or it was a small amount of shares. Well, Congress said, you can't have any share in a company that's in your courtroom, because that hurts the confidence of the public in the judiciary. And it's the very reason that the law was created. So finding any violations of this is a concern. We talked to a law professor at Indiana University, Charles Jay. Professor Jay said to us, this is a serious problem, because one little case, maybe not, but this seems to indicate maybe a systemic disregard for this important law.
James, I know you already told us how some of these judges responded, but it really was a range of responses, wasn't it?
Yeah, we definitely had a range of responses. I would say, as I mentioned, we have these 56 judges who've gone into court and essentially acknowledged wrongdoing. But they also said, many of them, one wrote a 22-page response explaining, well, I didn't even know what was in my stock holdings. My wife managed it, even though the law requires that he have knowledge. And the law says you can't rely on lack of knowledge. And in fact, they fill out the forms and their names on them for penalty of, if you put something wrong on the form, it's like your tax return, you could be charged with a civil or criminal crime. that was one thing. They could say, well, there was a misspelling in the recusal list. In the case of Judge Ramos in New York, he said, we missed this recusal because one word was missing. And he, the other said, well, the clerk's office missed it and should have gotten it. But the onus is on the judges. The judges, it's a law that applies to the judge. And we literally had some judges who did not know the law. I mean, their job is to know the law. Their job is to, to rule on the law. And the one law they didn't know about was the law that applied to them. And I think that raises some concerns.
Absolutely. Well, James Grimaldi of the Wall Street Journal, thank you so much for sharing your excellent reporting with us. We appreciate it.
Yes, thanks for inviting me. I really appreciate it.